Right out the gate, this courtroom wastes zero time. 3 separate felony cases, including forgery and child endangerment, and the judge is laser-focused. Notice how every guilty plea has to be crystal clear, voluntary, informed, and on the record. This isn't just paperwork, this is the legal system locking in accountability.
Edwin A. Okay, thank you. Give me just a second to get back where I'm supposed to be here. And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor, we will.
Ms. Johnson, in cause number 24, DCCR 2151, you're charged with the third-degree felony offense of forgery of a financial instrument from August 10th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Oh, did you catch that? A rare courtroom reality check. No contest might sound like a safer option, but this judge shuts it down instantly. Why? Because in many courts, judges want direct responsibility, not legal gray areas. Translation, if you're pleading here, you're owning it.
And are you pleading guilty because you did what they charged you with?
Your Honor, can we change it to no contest?
Nope, I don't take no contest. Okay. Or I know only under certain circumstances, but typically not. And then Ms. Johnson, in cause number 24, DCCR 2152, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from September 18th of 2024. And how do you plead to that charge?
Yes, ma'am.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
And then finally, in cause number 24, DCCR 2153, you're also charged with the state jail felony offense of abandoning or endangering a child with intent to return from September 18th of 2024. And how do you plead to that charge?
That's the same charge. You have the 2 counts.
Same charge with 2 different
Yes.
children, correct?
Yes, ma'am.
All right, so how do you plead to that one?
Yes.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all 3 of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Frazier?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreement that you've reached in the third-degree felony is for a 6-year deferred probation with a $500 fine, and you would be required to follow all of the rules and conditions of probation. And then in the 2 state jail felony cases, it would be a 5-year deferred probation with a $500 fine. And again, you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence? Well, it looks like there's no fine in 2153. So is it 500, 500, and then none?
Yes.
Okay. Any evidence that Ms. Johnson's not competent?
No, Your Honor, he's competent.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That will give me more information about you and your cases, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Your Honor, if I may, like to make sure on deferreds that my clients understand that should they.
Good morning, sir. Are you Christopher Morrell?
Yes, ma'am.
And Mr. Morrell, this is your initial appearance in cause number 25 DCCR 0466. You're charged with the third-degree felony offense of continuous violence against a family member from February 8th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yeah, I was understood that I already had
Right,
appointment.
right. So when you're in custody, we automatically give you an attorney, but once you make bond, I expect you to at least try to hire your own. So I'm going to reset your case about 30 days to give you some time to do that.
Yes, ma'am.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Absolutely.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying,
Yes.
and then we'll discuss your options.
Very good.
If you don't do that, then when you come back, if you don't do that, when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Understood.
Also, as a condition of your bond, when you made that bond, was it that you had no contact with Alonda Kelly?
Right.
Okay, make sure you follow that.
Now the tone shifts fast, from plea deals to serious domestic violence allegations. And here's a key legal insight: bonding out doesn't mean freedom without responsibility. This judge makes it crystal clear: if you're out, you better be actively handling your defense, or that bond can disappear fast.
Condition. No contact means obviously in person, but it also means communication in any way.
Absolutely.
No sending messages or anything, okay? If you do that and I find out, your bond could be raised and you'd be back in jail.
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you your reset notice. All right, and this is 25 DCCR 0559. Mr. Rojas is going to translate for us. And are you Heriberto Chavez?
Yes.
And Mr. Chavez, this is your initial appearance. And you're charged with deadly conduct. Hold on. You're charged with deadly conduct, discharging a firearm from May 8th of 2025. And since you've made bond, have you had an opportunity to hire a lawyer?
I don't make a lot of money. For a court-appointed lawyer.
So you tested positive in court for methamphetamine, and I raised your bond to $150,000 with a drug patch. How'd you make that bond?
I have a lot of family here and they all owe me money. I have a lot of family, parents and uncles and aunts.
If you can make a $150,000 bond, then you need to try to hire your own lawyer. So I'm going to reset your case for 30 days. So I'm going to reset your case to give you some time to hire a lawyer. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you cannot hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts and have different payment plans. You need to bring me back the names of the lawyers that you talk to so I know you're trying. And then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond again, and you would go back to jail. Do you understand?
So before I come back next time, I have to have a lawyer?
You're ordered to at least try to hire someone.
Wait, hold on. You tested positive for meth, had your bond raised to $150,000, and still made bond. The judge immediately spots the contradiction. If there's enough financial backing for that, there's enough effort to hire private counsel. This is courtroom economics in real time.
And
So if they're charging me a whole lot, at least I'll bring you the page showing you if they're charging.
Yes, at least for three different lawyers. Do you understand?
Again?
Okay, step in front of the clerk and sign your reset notice. Good morning, ma'am. You're Veronica Randall. And Miss Randall, you've been here before, I think, with Mr. Vasquez, and he filed a motion to withdraw, and I don't remember if I told you already to go try to hire a lawyer. So have you had an opportunity to hire someone or try to hire someone since you were here before? Is that correct? I think the memo on hers might be for somebody else. Okay, sorry, that confused me. All right, so Ms. Randall, what I'm going to do is I reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of who you've talked to at that next court date, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail for not following that court order. Do you understand? All right, if you step in front of the clerk, she'll give you that reset notice. Good morning. You're Sydney Boudouin? Yes, and Ms. Boudouin's charged with aggravated assault with a deadly weapon and cause number 24 DCCR 1944. And what is the announcement?
Judge, I believe Mr. Nichols and Mr. Roebuck have reached an agreement for a refile, and as soon as we get a date certain for that, we'll take care of it and dispose of this case.
Okay. Okay, so I'll just do a normal reset. If something doesn't happen between now and then, obviously we'll need something to happen here on that next court date. Stay in touch with Mr. Roebuck so that you know when to go to the other court with him the next couple of weeks or so. Okay, thank you. Good morning. Are you Hillary Lawrence? Yes, ma'am. And Ms. Lawrence is charged with theft of service and cause number 25 DCCR 0296. And what is the announcement?
Your Honor, I provided some discovery to state this morning. I think we're going to be able to work this out with a possible dismissal for restitution. We need to determine what that is.
Okay.
And so we're asking for a regular reset so we can determine what that is.
Okay.
That's correct.
All right, we'll do a normal reset. Ms. Lawrence, make sure you stay in touch with Mr. Parker and your bondsman. They'll let you know when your next court date is. All right, you're free to go. Thank you. And then, Mr. Parker, you have Jamarian Martin. Good morning. Are you Jamarian Martin? And Mr. Martin is charged with burglary of a building and cause number 25 DCCR 0196. And what is the announcement?
Your Honor, he's asked me if I could get a reset so he can come to the office, take a more in-depth look at this case.
Okay.
I've told him he needs to do that, and I've got an offer, and
all right, so
Mr.
Mr. Martin, I'm going to reset your case 30 days. Don't wait till the last minute to call and make an appointment with Mr. Parker. Call this week, make an appointment, go visit with him, and then we'll figure out what y'all want to do with the case at the next court date, okay? All right, you're free to go. It's Palilero Carduas.
Sorry, that's the name it's under.
Sorry. Is that the wrong one? Good morning, sir. Are you ABM Palilero Carduas? And Mr. Palilero Carduas is charged with evading arrest or detention with the use of a vehicle and cause number 25 DCCR 0202. And what is the announcement?
Your Honor, we've received all the discovery. I've sat down with Mr. Nichols. I now have an offer. If you would just give us 30 days, I'm quite certain the case can be disposed of. I just want to show him what I have.
Sure. Any issues, Ms. Malfino? All right, sir, I'm going to reset your case about 30 days. Make sure you call and make an appointment. Go visit with Mr. Padgett now that he has all the information and discovery, and we'll get an announcement at the next court date on what you're going to do with your case, okay?
Thank you, Your Honor.
Thank you, sir. Good morning, ma'am. Are you Dell Johnson? And Ms. Johnson is charged with indecency with a child by sexual contact in 24 DCCR 1570 and aggravated sexual assault of a child in cause numbers 24 DCCR 1571 and 1572. And Mr. Price, what is the announcement?
Your Honor, the announcement is not ready. We have received a full set of discovery materials from the state. We've also received the materials we subpoenaed from BISD and SILSB ISD.
Okay.
Received the SILSB ISD materials within the past week and a half or
Okay,
so.
good.
There is some new information there that we've got our investigator following up on, and that we anticipate that will take some time. In addition, we anticipate filing a motion for expert witness funds. We are in the process of speaking with several prospective expert witnesses to determine the best witness. and that process is ongoing. We're working diligently. We're asking for a reset, and we're prepared to update the court on our progress.
So this, I know there was some issues getting some of the discovery, but at this point, we are over a year into the case, and it looks like you've been on for quite some time. I'm going to reset it one last time. So whoever's working on whatever they're working on, they need to get busy so that you guys can make an announcement at the next court date, whether or not there's going to be an agreement or if it's going to go to trial. So this will be the last reset for an announcement. Okay?
Thank you.
All right, thank you. Good morning. Are you Precious Eaglin?
Yes, ma'am.
And Ms. Eaglin is charged with assault on a peace officer in 25 DCCR 0317 and aggravated assault with a deadly weapon in 250318. Mr. Rojas, what is the announcement?
Judge, I'm asking for another announcement. Dr. Eaglin wants to come in and look at the videos.
Okay. Anything you're waiting on, or you've got everything
We
now?
requested them. I don't know if I think I may have. I think they came in Friday. So I haven't had a chance to look at them.
Okay. So, Ms. Eaglin, I'm going to reset your case for about 30 days. It's important that you call this week, make an appointment to go visit with Mr. Rojas so you can see all the evidence and discovery that he has, and we'll get an announcement at the next court date.
Yes, ma'am. I'm gonna speak to the rental people.
The who?
The
Oh, okay, sure. If you'll just,
He's taking time on me. I didn't much know that. I can't much look at a video. I don't know really what's going on.
well, here's what you need to do. The way that you find out what's going on is to call Mr. Rojas and go sit with him in his office, and he'll go over everything. He'll go over what the state has given him. He'll go over what your options are, make sure you understand that. But that's, you're not expected to understand it all until you go talk to your attorney. That's what he's here for.
Yes, ma'am. That being said, I almost spoke to him, but we never once talked about that.
He's got, he just got the video, okay? So if I test you this morning, you're gonna have anything in your system?
No.
Let's double check that. Have a seat in the jury box. Good morning, sir. You're James Lofton? And Mr. Lofton is charged with assault on a family member by impeding breath or circulation. Oh, actually, this is an MTRP in that case. And what is the announcement?
Your Honor, we have to take care of a case down the hall before we can, but then we're gonna do, I believe, a modification of probation. Isn't that correct, Ms. Malfino?
Yes, Judge, after speaking with the probation officer, the recommendation is continuing on probation with the possibility of ISF if the court agrees, but he would need to plead first to the DWI, second down the hall. It was my understanding that was going to be done last setting. It has not. There's no sense in moving forward on this with that open.
When's that set?
It's set this morning.
Okay, y'all go take care of it, and then once that's taken care of, what I'll do, I mean, if y'all want to come back down here after you do that, we can go ahead and go through the motion, get the pleas. I can order an updated PSI, and then we'll have sentencing at a later date. We can get that all done today instead of.
That'd be fine with me, because
Okay.
that way he's got some stuff he's got to take care of before he checks
Yeah,
into jail.
it'll be, to get an updated PSI, we're looking at a few weeks anyway.
Okay.
So let's get the pleas today, get that updated PSI so that I'll know what is appropriate, what the probation officer says, and then we'll go forward at that point. So y'all run down the hall, take care of that. Just let the bailiff know when you're back in, or wave me down,
Yes,
and we'll
ma'am.
take care of that motion.
Sounds great.
Okay, thanks.
I've got one other
You
one.
do, you have Alexander Thornton. Good morning, you're Alexander Thornton?
Yes, ma'am.
And Mr. Thornton is charged with fraudulent use or possession of credit or debit cards in cause number 24 DCCR 0323. And what is the announcement?
Your Honor, the state had conveyed a plea offer. Is that, and it's my understanding, we might possibly plead that this morning, but Mr. Thornton has informed me since the last setting is that he is rejecting this plea, and he's signed a rejection form. Mr. Thornton,
Oh, I see it. Let me go through. Okay, hold on a second. Let's do that. So
So we're gonna need to put it on the trial document.
let me go through everything then. So Mr. Thornton, again, what you're charged with is a second-degree felony offense of fraudulent use or possession of credit or debit cards, and that's from September 23rd of 2023. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Barrington that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 4-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what the options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we will get that case set on the trial docket. Mr. Barrington will begin preparation for trial. Make sure you stay in touch with him. He'll let you know when you need to be back and ready for trial.
Absolutely.
All right, you're free to go.
Thank you, ma'am. May we
Thank you.
Excuse to
Yes, sir. This is Mr. Nichols on Precious Eaglin again, y'all. Yes, sir.
Judge, I was speaking with Ms. Eaglin in the jury box, and she indicated she wanted to address the court again about the drug use.
Okay.
Okay, honestly, forgive me for not telling you the truth. Just today, I lost my mother. It'll be a year. I'm not using it as an excuse, but I've been reaching out to help out, go talk to my caseworker and stuff like that. I'm going through therapy. Like,
What are you going
really
to test
wanted
positive?
to kill myself.
Listen, what are you going to test positive for?
For PCP. I relapsed on PCP. I've been clean. I had a sponsor. I've been clean on PCP for 2 years. And I just felt like I couldn't take none of this. And that's why I was asking, even out there, because I've been, my people that I'm seeing, those Saiga is out of Houston. So I had been set up everything with my son and my fiance to keep my kids, because I really gotta give me some help. I feel like I'm on a breaking point.
All right, hang on a second.
May I inquire, Judge, how she got here this morning?
Yeah, how'd you get here?
My nephew, he outside.
Okay.
You didn't drive her?
No.
When's the last time you used?
It's been going on like a week or so. So I had to go and like detox for a couple of days. I just did it by myself so I could start taking my medication.
Where's, would you call and get, have a seat in the jury box. I'm gonna have somebody come talk to you and then we'll decide what to do after that, all right? Get them back down here. Yes, so y'all were down in misdemeanor court already? Well, they'll walk him down, once we go back. Let's see, Mr. Smith on Darren Carter. All right, sir, you're Darren Carter? Yes. And Mr. Carter was previously in court, entered a plea of guilty to the reduction of charge. It was a Class A misdemeanor resisting arrest. And we reset this for sentencing to give you some time to take care of some business. And have you been arrested for anything since you were here and entered that plea? Any reason not to go forward with sentencing? All right, Mr. Carter, I'm going to find, again, you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of resisting arrest, the Class A misdemeanor. Sentence you to 30 days in the Jefferson County Jail, and you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Hold on, I'm trying to do two things at one time. I'm going to hand you the trial court certification. It shows this was an agreement that I followed, and so you have waived your right to appeal. It should be printed. Oh, I already have it. I think I printed it again. There's that, and you can go with the bailiff, and then they'll make sure he's going to need to go. Which is it, county court 2 or 3?
He needs to go to 2.
2. Okay.
Yeah.
Well, you'll make sure they can come get him maybe down there. He's in custody here for 30 days, and then he's going to go down there and do something. Thanks. Thank you, sir. Good morning, sir. You're Antonio Sanchez.
Yes, ma'am.
And Mr. Walker, will your client waive the formal reading of the indictment?
Yes, ma'am.
Take that. Mr. Sanchez, in cause number 25 DCCR 0790, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 25th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Walker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Hang on. I do want to go ahead and have her see what all you got, just so we have a baseline, okay? So we're going to go ahead and get that UA done this morning. So do you understand, it looks like the agreement that you've reached is for a 5-year deferred probation. There will be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sanchez is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's at that desk right there.
Perfect.
All right,
Thank you.
we'll see you back at sentencing. Thank you.
Let me excuse me.
Yes, sir, thank you. Good morning, sir. Are you Kelton Hebert? And Mr. Hebert's charged with evading arrest or detention with the use of a vehicle in 24 DCCR 1498. And what is the announcement?
Judge, we have received the discovery and I've gone through it. It does appear that there are some recordings that were missing from the discovery that were not given to the district attorney's office. So I would like to request that from them and see if that those recordings do exist or not.
Okay,
We've had that conversation, Judge, and I'm not opposed to a reset so that we can track that down.
okay. I'll just do a normal reset, give y'all some time to try to get that taken care of. And then, so Mr. Hebert, stay in touch with Mr. Galmore. He'll let you know when he gets that information so y'all can go over it and we'll see if we can get an announcement at the next court date.
Yes, ma'am.
All right, you're free to go. Thank you. Good morning. Are you Seneca McDaniels? And Mr. McDaniels is charged with unlawful possession of a firearm by felon in cause number 24 DCCR 1915. And Ms. Holmes, what is the announcement?
Yes, Your Honor, we're trying to work out some logistics. We've gone over different ways to get this disposed of, but I think if we, by the next court setting, we will have it done. If possible, it may be reduced, but if we could get a little bit more time.
All right, so I'm going to reset it one more time.
Yes,
This will be the last one. So y'all work out what you need to if you can. If not, we'll get that announcement at the next court date. Mr. McDaniels, make sure you stay in touch with Ms. Holmes so you can go over everything with her prior to that next court date, and we'll get an announcement on what's going to happen with your case. All right, you're free to go.
Okay,
Thank you.
thank you.
See, have we seen Mr. Jeffries or Mr. Adams?
Mr. Kelly's here for Mr. Jeffries.
Okay.
Kelly's here for Mr. Jeffries.
Good morning, Mr. Kelly. On David Boyd. Good morning. Are you David Boyd?
Yes, ma'am.
And Mr. Boyd is charged with deadly conduct, discharging a firearm, in cause number 250720. And Mr. Kelly's here for Mr. Jeffries. And what is the announcement?
Your Honor, I think that there is some media, either video or USB, that we might need to get. Am I wrong about that?
Are you talking about additional media or just the media in the case?
Just media.
Okay.
Do we have it already?
I'm not sure. I thought maybe you were suggesting that there was something out there that we procured. I'm sorry.
All right, I'll just do a normal reset. Make sure Mr. Jeffries gets that request in. Mr. Boyd, stay in touch with Mr. Jeffries so that as soon as he gets all that discovery, y'all can go over it and we'll try to get an announcement at the next court date.
Yes, ma'am.
All right, thank you. So, hang on. So, Ms. Eaglin, you were truthful in what you tested positive for, okay? Here's what I'm going to do. Typically, if someone tests positive for what you tested positive for, they'd be going to jail today. But I'm not going to do that, but I am going to order some very specific bond conditions. One of those is that you are going to have to get a drug patch. You have 24 hours to get that. Your bondsman can let you know where to get it. It's a patch that you wear on your arm. You have to get it changed every 2 weeks. It's obviously going to test positive this first time, but it needs to test negative after that. Do you understand? And also, I'm going to order, at least for now, that you are not allowed to drive, okay? You need to get a ride until you test negative for a little while. Okay, and then you're gonna have you visit with the people you're gonna visit with this morning, hopefully get a plan together, and as a condition of your bond, you're gonna be ordered to follow whatever plan. Make appointments, go to Spindletop, do whatever you need to do, okay? Because we want to get you back on the right path so we can take care of your case. So,
I don't know, I'm grieving.
well, they're going to give you some resources and where to go to try to get some help so that you can kind of get yourself together so you can work with Mr. Rojas and get your case taken care of, okay?
I apologize.
It's okay. So look, have a seat over there, but make sure between today and tomorrow you get that drug patch put on. They have a list over there. Okay. That's where you can get it taken care of. So when you're done with court, find out where you can get it taken care of and get that on before tomorrow, okay?
Thank you.
All right, just have a seat back in the jury box until you visit with Spindletop, please. Thank you, Mr. Rojas. Mr. Lofton, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Need to speak up, please, sir. And will your client waive the formal reading of the motion?
Yes, ma'am, we will.
Mr. Lofton, in cause number 16-24485, I have a motion to revoke your community supervision. Shows that you were placed on probation February 21st of 2020 for the offense of assault family violence, and that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated second on December 15th of 2023. And is that true or not true?
True.
And count 2 alleges that you failed to pay your court-assessed fees as directed, and as of December 20th of 2023, you were $5,946 behind. Is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? So I'm going to find that you enter those pleas true freely and voluntarily, find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and have the probation department do an updated pre-sentence report, give me more information about what's been going on probation with the new case and everything like that, and then we'll come back at a later date for sentencing. And so you need to stay in touch with your probation officer. Stop and talk to the one here in courtroom before you leave today.
Judge, it's my understanding that he's gonna plead to a short jail time down in misdemeanor court. Obviously, you have to do at least 72 hours, probably about 10 days. So he may be in custody when the update PSI comes back.
Okay.
And that is in contemplation of the fact that if the court agrees after the update, he will go to ISF as additional time.
In the substance abuse track, I would think.
Yes, substance abuse track with an extension of his probation, because obviously he was just told by the motion it's already expired.
Okay.
And Your Honor, just for clarification purposes, is my understanding from talking to the misdemeanor prosecutor that that any time he spent in an ISF would count toward whatever sentence they assessed down the hall.
Okay, so let's do this. As soon as that happens.
Which is set on the
25th.
Okay. So let's reset it just 1 week after that. Can y'all get that done in a little shorter time as on the update? It's okay. It's an update, so it's because I also want to make sure.
So if it's after the 25th, the following Monday will not do it. It has to be September 8th.
Is there any way we could?
We might could put it on the 2nd. That's a Tuesday. If he's in custody, we could put it on that Tuesday.
Do we have a docket that day? Let's do that.
I am set for trial on September 2nd in Jasper. Is there any way?
What about the 26th? Are we here?
Yes.
I'm fine with that. Of August?
Mm-hmm.
That's fine with me.
Is that okay for an update? Okay, we'll do it on Tuesday, August 26th. And that'll give you time to get that one, and then we'll need it be on a Tuesday anyway, now that I'm thinking about it, because he'll be in custody.
Right.
So, yeah, okay, perfect.
So
All right.
I need to get, for that hearing on the 26th, will I just go to the jail and do it?
They'll bring them over.
Oh, okay.
Yeah, we're bringing them over. So we'll see you on Tuesday, the 26th, once you're in custody. And we'll get that update. Not you. You're like, I'm going home. You're not out the door yet, Mr. Barrington.
Don't tell my lady.
You're free to go.
I agree with you. Thank you, Judge.
Thank you. Case number 24 DCCR 2310 on Ciandre Stevens. And are you Ciandre Stevens? Ciandre. Sorry. And Mr. Adams, will your client waive the formal reading of the indictment?
Yes, he will.
Ms. Stevens, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from October 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
And do you fully understand them?
Correct.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Answer out loud, please.
Oh, yes, ma'am.
Thank you. The court reporter's taken everything down. And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Correct.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. State tenders number 1.
No objections?
It's admitted. Is there any evidence that Ms. Stevens is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see y'all back at sentencing. Thank you.
All right.
Thank you, sir.
Thank you, Judge. Appreciate you.
Thank you.
Y'all take it easy.
You too.
And he has an add-on too.
Okay.
To review bond.
Let me see if there's a, let me make sure there's not an old one in here.
I wasn't sure if I had done one before.
No, I don't see one, so I'll hold it while y'all do that rejection. Mr. Young, just have a seat here in the courtroom. And you also have Jermaine Young.
I do, Judge, and I can make an announcement.
Jermaine Young,
He's sitting outside with his dad, Judge.
and actually I just looked for that rejection under Jermaine Young instead of Avery Young. Let me double check on Avery real quick.
You've got a plea of rejection under Jermaine, is that right, Judge?
No, I don't have one under Jermaine or Avery. Let me double check. Good morning. Are you Jermaine Young?
Yes, ma'am.
And this is 24 DCCR 0916. Mr. Young is charged with aggravated sexual assault of a child. And Mr. Burbank, what is the announcement?
Your Honor, I'm still waiting for some mental health records. That will be dispositive, I think, of this case once I can get them to the prosecutor.
Okay, and you've already requested
I
those?
did. Not through the court. I've been doing it
Okay.
myself. I'm sorry.
No, that's okay.
Of course,
If
they
you,
don't listen to me.
I was about to say, if they'll get them to you, that's fine. If you need an order, just file a motion and I can order it, and sometimes you get them quicker.
Yeah, because this will be dispositive of the case.
All right, so I'll do a normal reset, and if you need any help getting those, if they're not wanting to send them, just file a quick motion and I'll sign it without a hearing for you to get those.
Thank you.
Mr. Young, make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back. Any issues, Mr. Hoffpower?
No,
Okay.
just what counsel's gonna bring to me.
Okay, perfect. And I'll hold Avery Young and Diamond Smith.
Thank you.
Okay. Deferred probation, $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. January is not competent?
Not from the defense, Your Honor.
Mr. Hoffpower, is there any history, any reason not to waive the pre-sentence report?
Judge, we may need to have a pre-sentence report.
Okay.
There is a misdemeanor history.
Okay. So let's do this. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient...
This, right here, is where courtroom procedure collides with raw human pain. What started as a bond compliance issue suddenly becomes a mental health and addiction crisis unfolding live. You can actually feel the courtroom shift, because now, this isn't just about punishment, it's about survival.
Evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there behind you, okay? All right, we'll see you back at sentencing.
Thank you, Judge.
Yes, sir, thank you. All right, sir, you're Avery Young. And Mr. Young, in cause number 24, DCCR 1939, you're charged with the state jail felony offense of burglary of a building, and that's from August 9th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand? And I have here on the computer a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 21-month term in the state jail prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And you understand all of that. And do you want to reject that offer and have your case set for trial? And Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge. In fact, Mr. Burbank actually made a counteroffer just a few minutes ago, and I'm amenable to that counteroffer. If the defendant will take it today, it would be pleading to a misdemeanor criminal trespass with 6 months in county jail.
And so, Mr. Young, obviously you've gone over that with Mr. Burbank. I just want to make sure you understand that that offer would be off the table after today.
That's fine.
All right, we'll get it set for trial. Is there any issue with discovery? You'll have everything? All right, we'll set it on the trial docket. Stay in touch with Mr. Burbank. He'll let you know when you need to be back and ready for trial.
All right, thank you.
Brian Mitchell, Mr. Mitchell, we brought you into court today because of some issues with regard to, I think, the drug patch and how it's testing. You tested negative today, which is great. I just want to make sure that you are changing it when you're supposed to, showing up on time, making sure it gets changed, and obviously negative on each time. And I see Mr. Burbank just handed me, this was a hair follicle test that also tested negative. So I appreciate that. So I guess, is there anything that we can do today as far as an announcement, or do we just need to reset? It is already on the trial docket. We'll put it back on the trial docket then. But again, make sure you follow all of the rules and conditions of your bond with regard to that drug test.
Pertaining to my funds and the incarceration for this matter. What? What would be, it was a hair follicle taken. I was wrongfully accused of the drugs that were in my system. No, it was positive on the patch.
It showed a positive on the patch, and that's why we came in. There are times, sometimes there's false positives, sometimes there's not. It all depends, but that's why I brought you in here, because I did receive a patch result that tested positive for cocaine, and so I wanted to make sure we're all on the same page. You keep up those drugs.
This is judicial discretion in action. Jail was absolutely on the table, but instead, the judge chooses structured intervention, drug patch, treatment, no driving. It's a reminder that sometimes justice isn't about immediate punishment, it's about stopping someone from spiraling further.
Drug patches, you did the right thing by going and getting a test, so we should be fine, but just stay in touch with Mr. Burbank, follow all the bond conditions, and we'll see you back on your trial date. All right? Yes.
Without a trial, but
Okay.
I need some time and speak with my office to make sure
Okay.
we're doing everything.
Perfect. Are you Diamond Smith? All right, so I'm going to reset the case, make sure, give Mr. Hoffpower some time to get everything worked out that he needs to, get any information to Mr. Burbank that he needs to have, and let's see if we can get an announcement at the next court date. All right, make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back. Yes, thank you. Thank you.
Your Honor, when you're ready, the state's going to abandon the, I think we spoke to you earlier about it, we're going to abandon the last sentence of the indictment, which says the motor vehicle language.
Okay.
And that sentence ended at defendant.
Any objection to that, Ms. Norman?
No objections, Your Honor. It's to be a Class A misdemeanor from this point forward.
All right, let me,
And I think we reflected that on the paperwork.
y'all did. Let me see if I can. Look, I'm able. I just struck through a sentence on the computer. I'm just for everybody's information. Thank you. I need that.
Hey, whatever helps.
It does. Okay. Mr. Lopez, he waived the formal reading of the indictment as amended.
He will.
Mr. Lopez, in cause number 24, DCCR 1908, the state has elected to, well, you're charged now with the Class A misdemeanor of evading arrest or detention, and that's from July 24th of 2024. And how do you plead to that charge? Hold on, y'all marked it as a state.
The lesser included.
Was it on the state paperwork, Judge?
Yeah.
It needs to be in. All right.
I think we can make it work. The other paperwork just has a place where we can fill it in.
As opposed to write it.
Because none of this, all this Community supervision stuff doesn't apply on state jails. They're specific. I hate to do this, but would y'all please do it on the TDC paperwork, because it has a blank spot where you can write in Class A what the range of punishment is on all of that, and it doesn't have the